7-880 Hartman versus the Town of Stoughton. Would you please introduce yourself to the court and order?
Good afternoon, Your Honor. My name is Attorney Robert Hennigan, and I represent Michael Hartman. Mr. Hartman is in the courtroom, sitting in the front row with his wife.
Good afternoon, Mr. Hennigan.
Good afternoon, Your Honor. My name is Leonard Kessler. I'm employed as an attorney, and I represent the defendants in this case.
Very good.
Good afternoon, Your Honor. Michael Stefanello, also for the defendants.
Very good. I've read the papers. I've reviewed the transcripts that have been attached to the motions and the complaint. Let me start with the plaintiffs. Walk me through why the plaintiff alleges the town needs to discharge the plaintiff as opposed to allowing the contract to run.
Thank you, Your Honor. The issue here is he was appointed as a town manager. Mr. Hartman is appointed to that position by the Board of Selectmen. He doesn't need a contract to operate as town manager. But under Chapter 41, Section 108N, the legislature has given the towns the authority to enter into contracts for hiring people as town manager, give them benefits that they would not otherwise be able to have without some degree of negotiation. So when you have an appointed public official, as Mr. Hartman, who has a contract, and when there is a town charter that specifically, as a matter of law, identifies the way that particular position is to be discharged, you do not lose that right by way of entering into a contract under 41-108N.
Well, I'm looking at the town charter, C4-1, and it says the town manager shall serve at the will of the selectmen, except that a vote of the majority plus one of the full membership of selectmen shall be required to discharge him. Why isn't the contract that had an expiration date the will of the selectmen?
Because it's strictly a term of his position to be served under that contract. There's an entirely huge difference between his appointment as town manager and what the rights are between the parties as agreed under the contract. Even if you were to say that his term ends and for him to be discharged, it is still subject to a vote of the majority plus one, full membership of the selectmen, which would be required to discharge him. They don't lose, he doesn't lose that right.
So you're saying, if I understand your argument, not looking at attachment B, the defendant's opposition, which is as I understand it, the employment agreement that was in place until June 30th, 2017, you're saying that even though, I think this is undisputed, even though the plaintiff received the notice that's identified in paragraph 1, that within 6 months of the expiration of the agreement will not be extended, your claim is that the selectmen still needed to comply with the discharge provision in section 14.
Absolutely, and my position is stating that is as a matter of law, they have to provide, they have to follow. That's not something that can be contracted away or anything like that. That's a right that that individual has under the town charter for that position.
So you're saying the town charter, I should read the town charter to require that vote, even despite what the agreement says in paragraph 1?
No question, absolutely.
Walk me through the irreparable harm.
The irreparable harm, clearly, and I thank you, Ron, because I wanted to comment on this, because I read it in my brother's brief in opposition. He seems to take the position that the three selectmen have the authority to decide who the town manager should be, and that their right as elected officials is harmed if Michael Hartman returns back to his position. That's not the issue. The issue is the voters of the town of Stoughton voted this charter. The voters of the town of Stoughton voted the amendment to the charter, which put in the provision that they have to be discharged by majority plus one.
No.
So the harm comes...
But the harm is going to be to your clients.
Correct.
I'm not interested in I want to get to the harm to the town. Tell me what the harm, the irreparable harm to your client is.
He can't go to work. He can't perform his job. He's a authorized town manager. He's an appointed town manager who is being prevented from doing his job by way of the actions of 3 Board of Selectmen members.
And that's irreparable how?
It's irreparable because he cannot perform the functions that he's under by law required to do.
But he could be compensated
Yes.
with employment wages and whatnot after the fact, can he?
But sure, he can be compensated his wages, but he's irreparable because he's not allowed to perform the job of which he's now obligated to perform. When you just simply say, well, somebody can be just compensated and his job opportunities and his job requirements can be disregarded, this is his career. This is a career position for him. He's been in this position all his life. For you to be, for someone, 3 members of a Board of Selectmen to say, disregard all that, we can pay him off. That doesn't go to, that ignores the issue of employment and his right to serve as town manager and to be discharged when he is in accordance with the town charter. 3 members of the board plus 1. To say that he has no harm whatsoever other than compensation is to ignore the whole idea of him being appointed as town manager and what duties and obligations he has under the charter to perform that particular job. He has a right to perform his job until such time as he's discharged under the charter. They had previous town managers work for years and years and years without an employment contract in the town of Stoughton, as we've alleged in the complaint. So this is not anything unusual. This is because 3 members of the board don't want him to serve as town manager. And when you take away that right, when 3 people can take away that right to his employment, that's irreparable harm. That is harm that he will never recover from. That is harm from a reputation point of view. That's harm from an employment dignity point of view. Those are issues that he shouldn't have to go through until and unless the board provides him discharge rights under the town charter.
All right, let me hear from the defense. I will give the plaintiff the last word.
Good afternoon, Your Honor.
Good afternoon.
He was hired for 3 years, extended for 1. That's the decision that was made at the time he was appointed. It is, in fact, it would be legal to appoint him to a longer term because of the 3-year max. The board cannot appoint. So he hired for 3 years. In this case, it ends up being a 4th because the contract was then changed. His employment ended on June 3rd. It ended. What this really is the plaintiff trying to convert the vote, the December vote, into a termination. And I suggest to you the case of the law is clear that it's not. That is not a termination. So this is, a situation where his employment simply ended.
So, you cited, and I went back to read Downing versus City of Norfolk. And I take it the town's position is there's 2 ways of ending the relationship with the town manager. There's the active approach of termination, and there's the passive approach of allowing the contract
To expire.
to expire. And you're saying it's the latter, and these 2 are separate and distinct.
Totally. Within the contract, it says during the contract term, he's still an employee at will, but he had to be discharged pursuant to the charter.
Then talk to me about your position as to what section C4-1 of the town charter means. And the line that I focused on, and I think the parties did, the town manager shall serve at the will of the selectmen, except that a vote of the majority plus 1 of the full membership of the selectmen shall be required to discharge him.
To discharge him. But he was hired for a 3-year term. They can hire him. They're trying to convert this 3-year term into a perpetual, he's always an employee, you have to actively terminate him. But if he's hired, if the selectmen hired him, expressed their will at the outset of the contract, you're hired for 3 years. You're hired, in this contract, the amended contract, you're hired until June 30th, 2017. You're hired until that time. They don't have to do anything else. If nothing happens, his employment ends. They don't have to actively vote to reaffirm what they did at the outset. That was the contract. He's not terminated. They can hire him for a term. That's what they did.
Talk to me about your view on irreparable harm.
Of course, in my view, there's no irreparable harm whatsoever. There's wrongful discharges all the time. There's litigation over wrongful discharges all the time. And there's compensation, there's monetary compensation for wrongful discharge. And that's what this is. So if Mr. Hartman in the end wins this lawsuit, there's ample compensation for him. There's nothing irreparable about this. I don't get at all how anyone could, with a straight face, argue irreparable harm for being fired wrongfully.
All right, anything further from the town?
No, sir.
Plaintiff, I promise you the last word.
Just finally, just very quickly, I do say to the straight face that there is a irreparable harm for Mr. Hartman, because working in and of itself is a right that he has under this contract. But let me go to this game that's being played about the language of the words. Well, we cannot renew, but that's not a discharge, or this little ruse of games of language. Again, Your Honor, the town charter is the constitution of the town. It is the law of the town, and it clearly says, no matter how you pass the words, that if you're going to get rid of him, if you're not going to renew his contract, whatever you're going to do, you have to discharge him in accordance with the town charter. And the town charter could not be clearer. It requires a vote of the majority plus one of the full membership. They have never had that. They have never tried to get it. They've never provided him any kind of a hearing that's involved here under the charter. This is a right that he has, Mr. Hartman has, when he engages to go to work for the town of Stoughton. He has an employment contract, but he also has all the rights that is offered to him under the town charter. And as a matter of law, he's entitled to be discharged, told not to come to work, based on a vote of majority plus one. Thank you.
All right, I want to thank both parties. I'm going to take this under advisement. I thought the police were very helpful. I realize this is an issue of some importance to the town. I intend to rule on it quickly. The only thing that I am ruling on, however, is the application for a temporary restraining order, whether there is a likelihood of success and irreparable harm under the packaging industry's test, whether that's been shown, whether or not either party prevails at the end of the litigation. We're not going to decide all that today.
I understand. Thank you very much.
Thank you for your time.